Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello again. We're moving on to the fourth lecture for bankruptcy and debtor-creditor law. This lecture concerns the information gathering, analysis, counseling, and drafting stage of a new client interaction. So, given the different type of client, an attorney might be representing the creditor-client, and in that case, the objectives you'll have information about in this lecture include areas like the causes of the creditor's distress, information gathering from the creditor, analysis of debtor's situation, analysis of alternatives if the debtor hasn't filed for bankruptcy. So there's a difference between whether they have filed or haven't filed because of eligibility issues and that sort of thing. And then counseling. The debtor-client type would information gathering, of course, takes place, and analysis in non-bankruptcy or bankruptcy is what takes place in the attorney's office, and then counseling the debtor-client and drafting of bankruptcy forms. And finally, if it's an involuntary debtor-client, you have an involuntary bankruptcy been filed against the debtor, there are 3 different stages. So we'll kind of combine them all together into some little clusters of information gathering as the lecture title presents. So, and if you have a debtor-client, the information gathering, analysis, and counseling and drafting of documents is the initial interaction with them. The information gathering process is, of course, who are we? Who is the debtor? Where does the debtor currently live? What is the debtor's employment situation? What caused the debtor's financial difficulties? What is the debtor's financial condition? And what are the debtor's assets and where are they located? And a few more things. Who are the creditors and where are they located? How much is owed to each creditor? Does the creditor hold a secured claim, an unsecured priority claim, or an unsecured non-priority claim? Has the debtor tried a non-bankruptcy workout? Is the debtor subject to pending lawsuits? Are the debts actually the debtor's debts? And what are the debtor's expectations and goals, and how will fees be paid? So the analysis for the lawyer and the lawyer's law firm staff is to look to whether non-bankruptcy or bankruptcy has the answer. So from the information gathered, the attorney evaluates it and considers alternatives to bankruptcy based on the client's case, and then determines whether to recommend the client should file and then formulates another course of action. Alternatives are possible. Non-bankruptcy alternatives can be less expensive and better received by creditors. Non-bankruptcy solutions do not carry the bankruptcy stigma, and not all creditors should be taken through bankruptcy because of the type of debt and a few things that go on in that area. Negotiation is where there could be an alternative if the debt can be negotiated, whether they can alter the terms of the original agreement. Maybe it's just a little bit of debt, a lot of debt to one creditor and no debt to other creditors. A lot of things go into play. Every case is completely different. The debtor may receive an extension of time, maybe as a negotiation or a debt reduction or a combination of these. The debtor must be able to make some payments for the debt to make a negotiation successful in the first place, and a negotiated agreement is governed by contract law. Consolidation loans are also alternatives to bankruptcy, allowing the debtor to consolidate all the debts into one large loan, a little easier to manage if there's income. Consolidated debt does not lower the debtor's total debt, so if they're looking to reduce debt, obviously it's not going to happen. And consolidated debt reduces the number of payments, so that's usually one of the reliefs of a consolidation. And it may take longer to pay off and be at a higher interest rate based on their credit at the time. Things may be looking kind of sad, and interest could be a little higher in some situations for some debtors. Credit counseling is an alternative to bankruptcy. These centers analyze the debtor's obligations and negotiate with creditors for a schedule of payments that the debtor can handle. They don't lend money, they distribute debtors' money to creditors. Credit counseling centers educate them as well as to their spending habits. Assignment for the benefit of creditors. Transfer of some of the debtor's assets to a third party to ensure payment of the debtor's obligation is a way of assigning for the benefit of the creditors. This is mostly a business debtor situation. It saves the debtor time and cost of bankruptcy and gives creditors a higher return, and liquidation would not give this higher return. It's covered by state statute in the majority of states. Next we go on to the choices of bankruptcy. Chapter 7 is the only bankruptcy that doesn't require a reorganization plan. And Chapter 7 trustee will sell the assets of the estate that aren't exempt and distribute the money according to the bankruptcy code. And it's available to most debtors. It's the most popular choice. Like 75% we learned in one of these this or another presentation coming up, I can't remember. They receive a discharge for those debts that are dischargeable. And then, as pointed out in a much earlier presentation, the individual's debtors will receive, a corporation that is, or a partnership, if they file a Chapter 7, it's simply a way of going out of business. Chapter 9 is an option for municipalities. It's limited, of course, to political subdivisions and public agencies or instrumentalities of the state. And, I don't know, I think we have a Chapter 9, we have some current statistics coming out. These are old statistics. We can get those through 2024. You're not going to see many. We'll see when we get to that slide. A Chapter 11 reorganization is one that's available to businesses, but individuals can use Chapter 11. It does require a reorganization plan. And the difference between this and Chapter 13, if I'm going to keep it simple, is there is no, the court does not, as a general rule, appoint a trustee. The debtor remains in possession of the property, so they're called the debtor in possession. And the court may appoint a case trustee. Chapter 12 is adjustment of debts of a family farmer or family fisherman with regular annual income. So to qualify, they have to meet the definition of family farmer or family fisherman. And the debt cannot exceed the statutory amount and not be less than the statutory percentage of the debtor's aggregate non-contingent liquidated debt. And this also requires a plan. Chapter 13 is an adjustment of debts of an individual with regular income. So, like, well, I can't compare that well, but Chapter 13 means that there needs to be an individual or an individual and their spouse. Non-contingent, liquidated, and secured and unsecured debts must be less than statutory amounts. and it requires a 3 to 5 year plan. We'll look over how that's done. Debtor lives under the plan and contributes income to the plan through the trustee, and the trustee disperses the monies according to the plan. Chapter 15, I've got another presentation that I'm going to do lastly. This doesn't cut this. Most of the lectures I don't have much coverage of Chapter 15 bankruptcy, but basically these were added through BAP CPA, the Bankruptcy Code in 2005, and it's prior to that there was a Chapter 15 about the U.S. trustee, but that was moved into the United States Code by Congress. It incorporates a model law on cross-border insolvency into the Bankruptcy Code, and it's a very rare type of filing as well. But again, I have a separate one that I put together, and I'm going to lecture. I've done that. I put it together, but I haven't spoken a lecture yet on this particular topic of Chapter 15. It's not really complicated, but it needs some explanation. All right, so I got some statistics. Unfortunately, I didn't get that Chapter 9 statistic, but these being the most popularly filed bankruptcies, you can see by the period ending December 31st, 2024, the types of filings. And so all filings equal, let's go with Chapter 13. Let's say all filings in 2024, they were 197,244. Business Chapter 13 was low, and you can see that non-business. So the majority of Chapter 13 are non-business. The majority of Chapter 11 are business filings. Chapter 7 being Chapter 7 is mostly non-business filings, and but the total filings, and quite a 500,000 filings in the United States in 2024. Debt counseling. This is, again, I've mentioned before in other lectures that debt counseling is a pretty essential area of the BAP CPA, Bankruptcy Reform Act. And it's another opportunity for the attorney and paralegal to gain additional information. And so the attorneys, well, I've got that mixed up. I'm not talking about the BAP. I'm talking about the client intake. You know, we sit down, we talk to the client, get an opportunity to gain additional information, reviewing with the client the information received, you know, that recommendation is made whether or not to file for bankruptcy, and decides what the debtor wants to do or the client wants to do based on the recommendations, and then fees are discussed with them at that time. The creditor-client may need attorney representation for situations where the debtor has not filed for bankruptcy or has filed a petition. Either way, the creditor would probably seek some guidance from an attorney, and then also an attorney's help would be needed, most likely for filing an involuntary petition against the debtor. The creditor-client the creditor-client's attorney will follow the same steps as working for a debtor-client: information gathering, analysis, counseling, drafting documents. So when dealing with a client, creditor as a client, information is more focused, and if the creditor is a long-standing client, the attorney will already be in tune with the problem. They've already discussed it. It's been covered in other conversations, letters, emails. So this is where the attorney is looking for alternatives for the creditor-client. So we've already done some analysis on alternatives of the debtor-client. Creditor-client looks at it from a different angle. And I should mention, from the NALA practice manual, book, the companion, the paralegal companion, you can't really see much in terms of to identify whether alternatives are really a big aspect of it. But There are some points that are minor that will allow you to use this type of analysis, but this is included so that you understand what the attorney's role is. So, creditor representation again. First of all, is the claim a secured claim or an unsecured claim? And I believe the next presentation will, 05 is what it's labeled, plus a title. That 05 presentation will have some more information on secured and unsecured. The secured claims are like your car loan, your mortgage loan, that kind of thing. And unsecured is, let's just say it easily, the standard credit card. The attorney needs to determine, first of all, has a debtor ever filed under bankruptcy chapter 7, 11, or 13? And then they depend, what these two factors, particularly whether they filed before, has a great bearing on what the advice to the creditor is going to be. So what the attorney and creditor then do depends on whether the creditor's claim is secured and the bankruptcy chapter the debtor has selected if they have filed bankruptcy. The analysis on the creditor side is if the debtor has not filed for bankruptcy, they advise the client that there are alternatives for the debtor to activate. Private alternatives we've already discussed. State court alternatives are available to creditors and debtors, and involuntary bankruptcy alternatives. Private alternatives could just be standard collection efforts, continuing with those to collect the debt through a credit agency, something, or a collection agency. It's maybe pulled together with other creditors of the debtor to solve the creditor's problem, help the debtor find a remedy to its financial problems. That's another way of dealing with private alternatives. So, looking at an analysis of the alternatives, if the debtor has not filed for bankruptcy, there are state court alternatives, and hang on a minute. The alternatives if the debtor has not filed, there's a prejudgment. All of these really could apply to both debtor and creditor representation, but prejudgment garnishment, self-help repossession, getting a judgment lien against the debtor, supplementary proceedings are I'm not really sure what to tell you about what that means, but attachment of property, if the debt does not already include some type of attachment, maybe disposition or repossession and disposition of the collateral, repossess and sell the car, for example. Execution lien is like a share of sale, sort of. Post-judgment garnishment, receivership, where a receiver, a sort of trustee, not a U.S. trustee, not a bankruptcy trustee, sort of acts as a fiduciary. There's retention of collateral, maybe even, I will say that a lot of what you're going to see in this bankruptcy thing, these same bankruptcy practices can be done without filing bankruptcy. And I think really if there's anything about this slide to help you with that, is help you understand that, is bankruptcy is looking at everything and all the possibilities within it. Self-help alternatives, or I should say alternatives if outside of bankruptcy, are possible, and they can look a lot like the things that go on in bankruptcy. Reaffirmation, for example, if we haven't discussed it yet, we will. I think we did in Chapter 7. When we talked about Chapter 7 bankruptcy. So all this stuff still keeps going and flowing along. But there are always alternatives. If the alternatives, if the debtor has not filed for bankruptcy, an involuntary bankruptcy alternative would be discussed with the client, either Chapter 7 liquidation or Chapter 11 reorganization. Counseling with the creditor-client. You typically need another meeting to review the information they found. After the first meeting, they found, bring in alternatives, make recommendations, and then draft bankruptcy forms if it's decided that an involuntary bankruptcy should be filed. If we're dealing with a debtor-client and an involuntary bankruptcy, the attorney would be looking at the petition. Of course, the debtor may concede the petition and allow the order for relief to be entered, and as requested in the petition of the creditor. And the debtor could also concede the petition and allow the order for relief to be entered under a different chapter. And the debtor may contest the petition and assert available defenses. So if they go in under I don't think creditors can file Chapter 13s as an involuntary. It has to be Chapter 7 or Chapter 11. So that's what we're getting at here with this slide, is that maybe they assert in their petition, the creditor's petition, a Chapter 11, and the attorney and the client meet together and think that 7 would be better. That's what they mean in the second point: concede the petition and allow the order for relief to be entered under a different chapter. So, reviewing this, I won't go through each one of these. We've gone through it, but if you need some little study notes to keep handy, this is what the process is like as far as information gathering. And bankruptcy statistics and deadlines, they're always interesting. Debt counseling and creditor-client representation. The attorney reviews the client information, makes recommendations. Debt counseling process. Part of the attorney's job is debt counseling, so it's not the same as the debt counseling that comes through the 188-day prior requirement under the Bankruptcy Protection Act. The creditor-client representation also means gathering information, counseling, drafting documents. And the analysis of bankruptcy alternatives should always be considered with both creditor clients and debtor clients. And options for creditor and debtor clients might also be as we just discussed. If we can pull together creditors and solve it without bankruptcy, involuntary. Basically, the job is the same. All the drafted bankruptcy forms are sent to the client. Debtor clients in involuntary bankruptcy can make some options that we just discussed in the last slide, in the earlier slide. So that concludes this 4th lecture. Thank you very much. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.